We are going to start with the three threats to your estate because understanding those three threats will help you create a living trust that protects you from those three threats. Then we'll talk about the four steps to creating a living trust, and then the three different ways you can go about it. Because I know you're not just here to learn, you're here to actually get your estate plan done. I will leave room for Q&A at the end, so jot down your questions or put it in the chat. All right. So a lot of us spend most of our working life building this beautiful legacy, this cake that we want to hand over to the next generation. Our children, nieces, nephews are beneficiaries, not realizing that there are many unwanted guests waiting with forks in hand. And if we don't plan properly, then this beautiful cake will reach our beneficiaries with a big chunk missing. Or by the time it gets to the grandchildren, there's only a slice left, or worse, crumbs. In this webinar, I want to show you what you can do to make sure that this cake reaches your beneficiaries as intact as possible. Okay, so we need to understand what are the three threats to our legacy. Who is trying to take big bites of our cake? Jayne Mansfield was a successful actress. I want to start with this story because it really illustrates the first threat. She died without an estate plan. She was only 34. When you don't have an estate plan, the courts will use the default plan. So the first thing the courts did was to split up the four children because the default plan is for children to go with their respective fathers. And her four kids had two different fathers. So they were split up, even though she would have wanted her mother to raise her four children together. The children were not allowed into their home because the house was frozen. That's what happens at probate. Your assets are frozen. Even small items were locked down. Her daughter wanted a charm bracelet, a sentimental, value, and she was denied. The bracelet was sold by the estate for a few $100s. It took 10 years for her probate to wrap up, and her children were minors when she passed away. At the end of probate, a little of her money went to paying off her debts. The rest went to probate. So when her children were 18 and ready to get their inheritance, there was nothing left. It's a heartbreaking story, but it's not limited to celebrities. This recent article by Forbes shows how many families are unprepared for the cost of probate. Not only is it an emotional toll because your assets are frozen, it's very stressful during a time of grief. It takes 20 months on average. That's almost 2 years. And it costs 3% to 7% of your assets because of court fees, assessment fees, hiring attorneys, probate attorneys, and so on. So if your estate were a nice round number, say $1 million, and your probate went very smoothly, no family drama, no surprises, everything, no huge delays from the court, and it only cost the lower end, 3% of $1 million is $30,000. That's money that could go to your spouse or your children's college fund. It shouldn't be going to the courts. So this is the first threat to your legacy: the delays, stress, and cost of probate. Threat number 2 to your legacy is family fracture. I'm sure you've heard of stories of families breaking up because of an inheritance. Something good, inheritance ends up breaking up the family, and we all go, "Oh, that's so sad." But the same thing can happen to our family if we don't understand the causes of family fracture. Probate cracks families. You are not surprised because probate is so stressful and expensive and it's public. So outsiders whisper things in your ear like, oh, that doesn't seem fair. Oh, you spend, so much time taking care of your mom. You should get more, and so on and so on. So all these things definitely will put any loving family on edge. But the reason you get more family breakups with probate is because probate provides a ready-made venue for disputes. The judge is already there. The a complaint system is already built in. Lawyers are lined up. So all it takes is one disgruntled or confused heir to complain, and then it just escalates from there. So that's a big source of family fracture, probate. The second source of family fracture, surprisingly, is the family home. Don't think of the family home as just another asset. It's an emotional asset. It's Christmas mornings, it's baking with mom in her kitchen. It's also an unequal asset, meaning that perhaps one child has, put her career on hold to take care of mom, or another child has spent a lot of her own money to fix up the home. It's really hard to think about how to divide the house in that kind of situation, especially since the house is illiquid. So that's usually can cause family fracture as well. And the third reason for family fracture is surprises. Mom saying one thing, dad saying another, or mom saying different things to different children, last minute changes, hidden accounts, or unexpected debts. Unequal gifts are not bad categorically. It's just that when there's no explanation and they find out, when mom died, that, oh, the older child, this actually is quite common in Chinese families where the oldest son gets a bigger share, and if my siblings and I have been growing up in America, that would totally, catch us by surprise. Try to limit surprises to birthdays, not finding out in your parents' trust and will. So that is the second threat, which I think is very costly and sad, because the biggest inheritance you get from your family is not like money and wealth, material things, but actually that your siblings, your family is still intact, that you can still have Thanksgiving together. Okay, going to threat number 3. What do you think it is? A lot of people think it's Texas. So let's explore the death taxes that a lot of people are deathly afraid of, no pun intended. The first of the death taxes is the estate tax. This is tax that's imposed on the person who passed away. Of course, he's not around to write a check, so it's taken out of his estate. That's why it's called estate tax. Fortunately, even though it's very high, the tax rate is 40%, that's almost half. The exemption is very high, $15 million. The federal government is only after the whales. So for a couple, that's $30 million. If you don't have more than $30 million for a married couple, you don't have to worry about the estate tax. The second tax is the inheritance tax. That's tax on the person receiving the inheritance. Okay, guess what? In the US, there's no inheritance tax. You could inherit $1 million from a surprise uncle somewhere, anywhere in the world, and you would pay zero inheritance tax for receiving that inheritance. The third tax is the profit, the capital gains profit. When you make a profit, if your house appreciates, your stock doubles, or your business grows, the government wants a piece of the profit. So that is called the capital gains tax. Well, there is a rule that says when a person inherits an asset, the cost basis of the asset steps up to the market value at the person's death. So That's called a step up in cost basis. So the person inheriting the asset could sell the asset the next day and pay zero capital gains. Let's see how these taxes play out, okay, in a scenario. Remember, these are federal level taxes. There are also they're also state level. But for estate tax, the number of states that have exemption limits 3 million or under is only about 5 states, and there are only 3 states so very, very few states that have an inheritance tax on children. Actually, only 2 states on children or spouses. The rest waive it for children and spouses. So let's see how these taxes play out. Okay, Mike inherited quite a large estate from his father, a house that appreciated from what his dad bought it at, 400,000 to 1.2 million, an IRA, Roth, and some stocks that also appreciated, a life insurance policy, and a rental property. All in all, $4.5 million. When Mike first found out, his first thought wasn't, whoa, I struck the lottery. No, his first thought was, I'm going to be hammered with taxes. So let's figure out his tax bill, okay? All right, let's start with federal. What is the estate tax at the federal level? If you remember, the exemption cutoff is $15 million. This isn't even a third of the way there, so zero. What about the inheritance tax? There's no inheritance tax at the federal level in America, so another zero. What about the capital gains tax? Because the house appreciated a lot, the stocks appreciated, the rental property appreciated. The cost basis step up means that the capital gains is zeroed out. So there's no capital gains tax. So far, federal tax is zero. But remember, there's the state level. Because he lives in Florida, the estate tax, as I mentioned, about 2/3 of states do not even have an estate tax. Okay, Florida is one of them. So the estate tax is zero. What about the inheritance tax? There's no inheritance tax in Florida, another zero. Capital gains tax, zero. So Mike receive a $4.5 million inheritance and pays zero taxes. Now, if Mike lived in my state, Massachusetts, let me show you that some states do have a state level estate tax. These are the only states that have state level estate tax. Their exemption limits are quite high. Connecticut is 15 million. Again, if you have under 15 million, no worries. If you live in DC, under 5 million, no worries. The ones I highlighted have exemption of 3 million or less. So if you have anything above 3 million, then you would be paying a state level estate tax. But you can see that's just 1, 2, 3, 4, 5. That's just 5 states out of 50 states in the US. And that's only if you exceed 3 million. And in Massachusetts, it's 2 million. Remember, we talked about that scenario. So if Mike's dad used his $2 million exemption, his mom uses her $2 million exemption, total 4 million. So Mike only has to pay tax on $520,000. And the state level estate tax is not 40% like the federal. In Massachusetts, it only goes up to 15%, 16%. So you see, this fear of death taxes actually is something that won't hit the majority of Americans. That's not the third threat. Do you know what the third threat is? It is inheritance wealth erosion. What do I mean by this? Say your legacy, your estate, dodged probate, okay? And then it also dodged family structure. Great, your kids are still having Thanksgiving together joyfully. And it also dodged the death taxes without too much effort. And they finally make it intact to your heirs. Guess what? A new set of risks show up. Dangers to our heirs' inheritance. First is a lottery winner's curse. I'm sure you've heard of it. Lottery winners actually lose their winnings in a few years, and some of them are actually worse off than before they won the lottery because too much money too quickly without guardrails makes you do stupid things. If we don't plan properly and our heirs get our inheritance outright in one lump sum overnight, they might fall prey to the same curse. High risk ventures. This is the opposite. Some children feel so responsible about their inheritance that they feel pressured to grow it. So they get into high risk ventures that they don't know much about and end up getting scammed. Are your children in high risk professions where lawsuits and professional, liability is more common? Then if they own their inheritance, then that also becomes exposed to those risks. How about a potential divorce? Now, let me explain this. Inheritance is considered separate property. It's not considered marital property. It's just that after, years of marriage, it gets commingled easily. Let's say the person with the inheritance use it to cover a mortgage for 1 month because the family was tight. That's commingling because the mortgage goes towards a joint asset. So if you use your inheritance towards a joint asset, at the event of a divorce, the other party's attorney could claim that that inheritance had become marital assets and half of it will walk out with the spouse. There are many other ways that it can get commingled. Or heirs passing away. So in this case, a young man inherited quite a sum from his father. And before the young man created his own estate plan, he passed away. So by default, everything he owned went to the next of kin, which is his spouse, who remarried. So essentially, this young man's inheritance just left the bloodline. These are all the possible dangers of our heirs' inheritance if they're not protected. This 20-year data of 3,200 families shows that by the second generation, only 30% of the inheritance is left. And by the third generation, only 10%. So my analogy of this whole cake turning into just a slice and crumbs is not really an exaggeration because of these three threads. If I were to tell you that there was one simple thing you could do to protect yourself from probate, from family fracture, from inheritance erosion by your heirs, would you do it? My guess is that you would. That's one simple thing is a living trust. Okay? So we just talked about the three threats to your estate. Now we're at the section talking about how a living trust protects you against those three threats. A well-designed living trust needs to protect you against probate, keep the family whole, and also preserve your children's inheritance. A lot of people just talk about, probate, but that's just the baseline. That's just step one. How does a trust protect you from probate? By transferring the assets into the revocable living trust. You still maintain authority over the assets as trustee. You can sell the house, refinance the house, rent it out, but you're no longer the owner of the house. The assets are titled under the revocable living trust. So when you pass away, then there's no need to go to probate because probate is caused by dying with assets still in your name. So the courts have to step in to help you transfer those assets. But if the assets have already been transferred into the living trust, then that protects you from probate, which is why a will does not avoid probate, because a will is essentially a letter to the judge saying, I want this house to go to this person, this bank account, but the assets are still titled in your name. Try to remember when you bought your house. How would it feel if the seller says, hey, thank you for giving me all this money for the house. I'm going to write a letter that says that I would like to give this house to you. No way. You want him to sign off on the title. That is why a will does not protect you from probate, because the title is still under your name. The courts still need to oversee the transfer of the title from your name to your heirs. How does a trust reduce family fracture? By avoiding probate, because probate is the biggest source of family fracture. A trust also encourages intentional planning. Doing the trust forces you to reflect on the choices, on the dynamic of your family, and it also makes you get clarity, and hopefully you're communicating your wishes to your family, and not be surprising them. So all these factors help to cut down surprises and reduce family fracture. How does a trust protect the inheritance? We talk about the risk of inheritance erosion. Well, for one thing, a trust allows you to stagger the inheritance. For example, you could say, when my children hit 30 years old, they get a quarter of their inheritance, and they get the rest at age 35. You know your kids the best. You pick these ages. Just by staggering them and giving the young people, a chance to get more experience in the school of hard knocks will make them wiser, is the idea behind here. Even though they don't own the inheritance, they can still access it for health, education, maintenance, or support needs. I think this is the best of both worlds, because the inheritance is protected, but if there ever comes a need for health, education, maintenance, and support, they can access the funds. And who, decides or gives them? The trustee. You will have a trustee, a manager, to manage this trust. The staggering, the limit, the distribution, limitation, and having a trustee. These are safeguards that will reduce the chance of the inheritance being squandered away. That's how a living trust solves those three threats. Now we're going into the section on 4 steps to create a living trust. Think of it as building a house. The first step, key decisions. Before you hammer your first nail, you just have some basic ideas. Is it a 2-bedroom, a 4-bedroom? Is it an open layout? Is it an open kitchen? And so on. Step 2 is creating the plan documents, finding a team that will build the house. And step 3 is getting the house inspected, sign off, approved. And step 4 is actually moving in and getting the protection of the house. You'll be surprised how many people spend money creating a living trust, and then they don't transfer their assets into the safety of the trust. That's like building a house and not moving into it to enjoy the protection of the house. So these are the 4 steps in summary. Let's drill down into each of them. Key decisions. Before you walk into the attorney's office, before you sign up on an estate planning platform, what are some things you want to think about? If you're married, then you want to think about, when the first spouse dies, do you want everything to go to the surviving spouse, or do you want it to be split up into the surviving spouse, and the deceased spouse will have locked up in a trust, in a separate trust called a marital trust? And this is very helpful, especially for blended families, because a trust like this will take care of the surviving spouse for needs, but the principal is protected for his biological children. So it prevents stepchildren from being disinherited. Sometimes it's not a blended family. Sometimes a surviving spouse may be in a high-risk profession where lawsuits are common. This is another way of protecting the deceased spouse's share. Or the surviving spouse may get dementia or not able to protect herself from scams. So there are several reasons, but these are things that you start to think about. If you have children, what ages do you want the children to get their inheritance? Who will be the manager of the trust? There are parents who feel their children are actually quite good with money and responsible, so they make their children trustee. You can also set if you want to allow your beneficiaries to redirect the trust funds, you can be very limited and say only along your bloodlines, or you can be very broad and say I will let my beneficiary decide whoever they want to redirect trust funds to. If you are incapacitated, who will speak on your behalf regarding healthcare matters? Who will speak on your behalf regarding financial matters? These two are for when you're incapacitated. A lot of people think they just have to plan for death, and they forget that sometimes we get incapacitated, and you need these roles to speak, to advocate on your behalf. If you have minor children, who will be the guardian? Otherwise, when you're no longer around, who will be the successor trustee? So these are some things that key decisions you want to think about before you even, start creating the trusts. The next one is creating the plan documents, choosing the right team, right? When it comes to estate planning, if you're not using an attorney, then you want to get a best-in-class online platform to draft the documents for you. These are some features you want to make sure that the online platform you choose have. First thing is you want to make sure the platform is easy to use and yet powerful, because it has to protect you and be able to create all those safeguards that we went through. You want to make sure that the documents are attorney drafted, not AI, and not something that is just pieced or mangled together using templates, but that a team of attorneys are behind the platform. You want to make sure it's tailored to each state, because different states have different requirements. And definitely have not just chat and email support, but phone support, because chances are it's your first time doing it. So it's very hard to, just chat back and forth. It's great if you can pick up the phone and ask questions. Checklists and summary reports are also essential. I'll explain why later. And definitely the security, because you're putting in some confidential information. Never put bank account numbers or bank account balances in your trust. That's not what I mean by confidential information. I mean confidential information such as your distribution decisions, your preferences, your beneficiary selection. So that's step number 2. Now I want to show you some examples of what that looks like. So Wealth.com, which is the online platform I partner with, the interface is question driven. You are simply answering one question after another. It's simply checking off boxes and making selections. The Wealth.com also has the summary reports of your key decisions. Do you know why a lot of plans don't get updated? They just get shoved in a drawer somewhere, because nobody gets excited looking at 60 pages of legalese. But when you have summary reports that you can just pull out once a year to review your key decisions, it makes it easier for you to spot if there are any changes you need to make. That's why those are important. And a signature checklist, because a lot of documents get invalidated when they don't have the right signatures. And here, a signature checklist can be very clear which document needs which signatures by whom, whether some documents need witnesses or not, and then which documents need to be notarized. A lot of DIY trusts and wills are not valid because they're not signed properly according to the state's requirement. For my clients, I suggest, before you go to the notary public office, use some yellow stickies and tag your pages so that you're not flipping through 60 pages in the notary public's office and end up missing some pages. Signature, witnesses, notary, very important. And the fourth step is funding your trust. That's a technical term. All it means is you're transferring the titles of your probatable assets, because not all assets belong in a trust, okay? Example, individual retirement funds, IRA. I stands for individual. If you transfer the ownership into the trust, it's going to trigger withdrawal taxes. The IRS considers that as a withdrawal. So step 4 is transferring the titles of your probatable assets into the trust so that when you pass away, you don't have to go through probate. So those are the 4 steps to creating your living trust. Now we're at the section on how to actually go through these 4 steps. What are the implementation options? All right. So traditionally, if you are not working with an attorney, then your options are to do it yourself or to sign up for an online course to learn how to do it step by step. Doing it yourself, you really have to piece, all the pieces together. So you need to do a lot of research to know what pieces to pull together, which platform to use, what's a checklist for a great successor trustee. You're weighing trade-offs. And even after all that, you still feel a little bit uncertain and confused because you don't know what you don't know. Online courses seems like a promise, step by step. So it's easy to start, but it's also easy to stall. Also, the software is usually extra. If an online course, like if a $300 online course includes a software, then it's usually not very robust. So they usually refer to a top of breed software. So that's a separate cost. It looks easy, but when you actually apply your own unique situation, you have questions and there's no one-on-one support. So the completion rate for when people do an online courses and finishing their plan is actually quite low. So tonight I want to present you a third option, which is working with an estate plan partner. It's not do it yourself. It's not paying attorneys thousands of dollars. It's partnering with a one-on-one guide. Estate plan partner, it's an all-inclusive one-stop program, and it comprises the engine, which is the wealth.com platform that will be drafting your documents, and a one-on-one guide, the certified estate planner, and a library of shortcuts, checklists, and resources to save you time. The focus is to get these 4 documents completed: the living trust, the pour over will, the healthcare directive, and the power of attorney. And this is a typical timeline for this when a client works with me. First, we do an onboarding meeting. And after this onboarding session, you would have created on wealth.com a draft of your living trust. So just one meeting and you will have a draft of your living trust created. And it's intentional that we don't finalize the trust in that one meeting because you really want to talk it over with your spouse. You want to think through your decisions because they have big impact. So the next step is for you to just review and finalize the estate plan. And then we have another meeting where we talk about how to fund the trust. That's that step of transferring your assets into the trust. An empty trust is a worthless trust. It does nothing for you. And that's not the trust's fault. Assets need to be in the protection of the trust to skip probate. You follow your trust funding steps, because I can't go with you to the bank to fill up a payable on death form. So you will have to execute the trust funding steps. And then we have another meeting to wrap up and talk about things like how often you should try to review your estate plan, how to share it with your family, what kind of information to prepare your successor trustees, that kind of thing. So this is the typical timeline. It's 4 to 8 weeks. Some families, urgent things push off important things, and it can go up to 12 weeks. But this is the general timeline of getting the estate plan done. Let's talk about costs. When I talk to a lot of people why they haven't gotten their plan done, it's not because they don't realize it's important. They absolutely know it's important. They've actually called an attorney and had a free consult, and then they get a sticker shock and the conversation becomes, oh, let's talk about this next year. So cost is a real barrier for a lot of people. For sure, don't do nothing, because probate will be your most expensive option. Even at the lowest 3%, like I said, that's $30,000 for a simple $1 million, $1 million estate. Attorneys, depending on where you live, for a complete set of documents could cost you between $3,000 to $5,000, and do it yourself will require you to sign up with a online planning platform. A couple ones out there that you may have heard about is LegalZoom, which charges $500 for a couple, or Trust and Will, which charges you $600, and you have 30 days to complete your estate plan. I don't think that's enough time, 30 days. When you work with the Estate Plan Partner Program, you get a one-on-one guide, you get a premium platform, and the resource list to save you time. So instead of just getting a course or a platform to figure out on your own, you're getting these three. What do you think is a fair value, considering these other options? What do you think is fair for a complete one-stop solution like this? Any volunteers? Well, the clients who have gone through this with me and seen the attorney quality of the documents, and they've experienced the one-on-one and also taken advantage of the resources, and also seen how they've grown in their estate planning. That's the advantage of doing this with a guide. Like your knowledge of estate planning just it's very different experience than just giving it to an attorney. So my clients who've gone through all that say that the value is actually worth more than what it would cost to work with an attorney. My cost is nowhere close to what an attorney charges. It's $795 for a couple, and that includes all the three components, includes the wealth.com subscription. And for single person, it's $695. But I can do better because you're my YouTube viewers. So if you take action by Monday midnight, you can use this coupon code TRUST200 to save another $200. A client asked me, Bertha, you're so generous in your YouTube. You share your book, you share your resources and all these videos. Why are you pressuring us to, with this deadline? Like, why don't you just give us the discount? Why do you pressure us with this deadline? Well, to be honest, it's because from working with various clients, I know that a lot of you have had this task on your plate for way too long. And I'm just trying to give you an incentive, a nudge to take action. You have spent so much time going through YouTube, researching, reading up a lot of stuff. And tonight you've spent another hour in this webinar. So I know you're not just trying to get more and more information. You're ready to take action. When I read this email from this client who says, "Thank you for igniting this fire under me," another client who said her husband passed away very shortly after she finished her trust and her will. I feel that it is my job to push, because we need an estate plan. If we don't have one and something happens, then the state will apply their own plan. And we already see how that doesn't serve us. So I see it as my job to give you incentives to act, to take action. So with a $200 discount for couples, it's $595, which if you remember, the trust and will was $695, and for single, it's $495. And you're not just getting a software, but you're getting a one-on-one guide. When we do our onboarding meeting, it's just you and me. That's why by the end of the onboarding, you're able to get your draft of your living trust done. Okay, and as an additional incentive, I have 3 additional bonuses. The first bonus is this 53-page estate plan checklist. I get asked over and over again the same questions. What are the things that will make a good successor trustee, or power of attorney, or what are things that I should put in my trust? What are things I shouldn't? So I decided to compile all these frequently asked questions into a book of checklists that will save you a lot of time. Bonus number 2. Another reason estate plans out there are so old and outdated, like maybe you have parents who have estate plans from 10, 20 years ago. The reason there's so many outdated estate plans out there is because no one is looking forward for another round of sticker shock going back to their attorney saying, "Oh, I have a new granddaughter. I want to add her as a beneficiary," or, my daughter is much more mature now. I want to make her a successor trustee. But with this bonus, you have lifetime unlimited edits, not 30 days. I have a client who said he paid for this, I won't say name, but he paid for this online planning platform twice, because both times the expiration date expired before he could even start. Anyway, that's not going to be your situation. You will have lifetime unlimited edits. Of course, as long as my partnership with Wealth.com is still active. 3 years from today, you can go back to Wealth.com, log back in. You don't even have to ask permission from me. You just log back in and make edits if you need to. Bonus number 3 is really special. It's a complimentary Wealth.com account. It's almost like buy one, get two. It's a Wealth.com account that you can give to your friend, your neighbor, or a relative who still thinks that a will is sufficient to avoid probate. This is a really wonderful gift. Don't give them any more stuff. Give them this gift that will spare their family from probate, from family fracture, from inheritance erosion. They get a Wealth.com account that they can create their plan, and all the resources, worksheets, scripts, and templates that I'm sharing with you, which is bonus number 1 and number 2. And they also get lifetime unlimited edits on their estate plan. The condition is that you will only get this bonus after your estate plan documents are completed, because I don't want you to get distracted. I rather you focus on your estate plan, get it done, and then, have that peace of mind, and then have the joy of thinking who you can gift this account to. To sign up with the program, the website is estateplanpartner.com. This is what the web page looks like, and you will choose whether you're doing an individual plan for single person or a couple plan. If once you make that choice, you will get the payment page don't forget to enter the promo code TRUST200 to get $200 off. And then it will ask you to book your onboarding appointment with me so we can just roll our sleeves and get started on that living trust. To summarize, the program with the discount is $495 for single, $595 for a couple. You get one-on-one guidance. It includes the Wealth.com platform and all the shortcuts and resources to save you time. The bonuses are the checklist ebook, lifetime unlimited edit, and a complimentary Wealth.com account for someone you care about. Thank you so much for your attention. That is all I have to present to you. We are now in the Q&A section. Don't hesitate to just turn on your mic and speak, and I'll do my best to answer them.